Welcome to Beyond the FAR from GW Law's Government Procurement Law program, where experts unpack the business of government. And now, here's your host, Dean Jessica Tillipman.
Welcome to the Beyond the FAR podcast. My name is Jessica Tillipman, and I am your host. All right, today we are digging into a critical issue in U.S. federal procurement system, small business contracting. Now, like many governments around the world, the United States uses its spending power to do things more than just buy goods and services. It also uses its power to advance a wide range of policy goals, including advancing the small business industrial base. The Small Business Act sets an annual goal. At least 23% of federal prime contract dollars should go to small firms. Now, this includes a wide range of small firms: women-owned, small and disadvantaged firms, HUBZone, service-disabled veteran-owned, among others. And for years, there's been a growing concern about a shrinking small business market in the federal procurement space. And at the same time we're concerned about that, we're seeing our entire field shifting with the FAR overhaul and the consolidation of a lot of procurement under GSA. So our guest today, our very special guest, is going to dig into all of this with me. Known as America's small business champion, he spent more than a decade at the Small Business Administration. Most recently, he served as Director of Policy Planning and Liaison, leading the government's small business regulatory work, goaling, and size standards. And before that, he was SBA's Deputy Associate General Counsel for Procurement Law. He now runs his own firm and writes the GovCon Intelligence newsletter. Sam Lee, welcome to Beyond the FAR.
So much for having me on. I really enjoy your podcast. I watched the last one on YouTube, and it gave me a lot to think about. It's a really excellent product you're putting out.
Well, I share a mutual admiration of your new newsletter, which I read every single time it comes out because it's fantastic, and we are so fortunate to have that resource available. So we will put a link in the YouTube channel and also put a link into the podcasting platform to Sam's newsletter so that you can subscribe. And I encourage everyone who's listening to do so because it's a phenomenal resource. Okay, so let's take a step back and just introduce everybody to what you did at the SBA so they kind of have an understanding of what role you played, and then what your transition into the private sector has looked like for you.
The main part was that 23% that you mentioned, the 23% goal for prime contracts with small business. I was in charge of that goal for the whole federal government. So part of my responsibility was splitting that goal up among the 24 agencies that we worked with, including Defense and DHS and Department of State. Each agency would get a goal, and then I'd track the goal, and then we'd issue it on an annual basis. It's more complicated than that, but we were very successful in pushing small business contracting to new heights. During the time that I was in that position as the policy director, small business contracting increased 50% all the way to $180 billion in the last year that I was at SBA. In addition to that, I worked on small business regulations. So there's a section of the small business Code of Federal Regulations, Title 13, that I wrote and drafted and worked with our OGC on. And then I worked on FAR Part 19 as well, which has just been overhauled. So a lot of the stuff that I worked on when I was in that position has now been rewritten or changed completely. And then you mentioned size standards. I was part of the group that issued size standards, and those are going over an overhaul right now as well. There's a post rule last year, and they'll probably finalize that over the next few months. For the services size standard, there's another set of size standards for manufacturing companies that'll probably come out in 6 months or so.
I'm fascinated that we are potentially still hoping to see those changes happen, because I know, for example, I've been very anxiously watching what happened to the OCI proposed rule that came out in January, just before the start of the Trump administration, and it feels like it's just like withering away in the atmosphere. So if there are still things that are happening that were started last year, that'd be amazing.
Yeah, it does seem like a return to normalcy whenever I see these size standards. Like, oh wow, this is normal. This is what
Yeah.
you're supposed to do. But it's good for small businesses because the economy changes and industries change and there's inflation. So if you don't change the size standards, then companies that are just growing because of just natural growth or the economy, the change in dollars, they will end up being, other than small, or they'll be large businesses just because of that, rather than growing outside of being a normal small business.
It's interesting that you said other than small because we have a lot of listeners from outside the United States, and
Mm,
typically they use the nomenclature. It's the
mm,
SME or small and
yeah.
mid-sized enterprise, and we just don't use that in the United States. I don't know if you've ever looked into that. I haven't looked into it, but we tend to have our own language for almost everything. So
Think it's
the way
just
we
people like
measure
the word
degrees.
small. It's better than an acronym, but really the definition of small business in the United States would probably cover what other countries consider to be medium, because small
Okay.
means you're not dominant in your industry. So it basically excludes large businesses, and then everybody else gets to be considered small. There have been talks at GAO and in legislation to create kind of a mid-size category, especially for government contracting. So businesses that go above the size standard can still have some preference, and they don't have to compete against the biggest of the contractors. That really hasn't gotten off the ground, just because SBA is in charge of the whole small business program, and they're SBA, they're Small Business Administration. They're not the Small and Medium Business Administration. They don't really have a
Yeah.
interest in going after these medium firms.
Yeah, and I think I said mid-sized, but I think I always said that, and I will add that to my list of things that I habitually can't remember whether it's medium or mid-sized or NAICS code, which I introduced my students to because I'm consistently hearing NICS, NAICS, NIAX. I've never heard of something pronounced more differently among our in our field than the NAICS code, but they actually have it on their website now, where they tell you how to pronounce
Pronounce
it.
an aches.
Yeah.
That should be our next YouTube video: how to
Yeah,
pronounce an
just
aches. That
how
really
to
gets it the
pronounce
right way.
things. The debate. Okay, so one of my baseline questions, and it was funny, I was having a debate the other day with one of my colleagues about this, because I have a separate article coming out on AI, but we were talking about extreme concentration in that area and the role of small businesses. And he said, I don't know why we even give contracts to small businesses. It seems totally inefficient. I don't know why I would do that, which gets to kind of the competing goals of a procurement system, where there is a genuine tension oftentimes between price and collateral policies and efficiency. And so, make your case. So why should people care about small businesses and federal money being, prioritized for them?
Oh, I have a case, but the reason has changed for the federal government over time. When business preferences first started, it was in the preparation for World War II. So this is way back in the late 30s and early 40s, and the um, FDR administration came up with the idea of having somebody go around to the federal, mostly defense buying at the time, federal defense buyers, and trying to encourage them to work with small businesses. So they selected a single person to do that, and the person was Robert Wood Johnson. Have you heard of Robert Wood Johnson?
No, but I'm
He
loving this history
well,
lesson.
he was the president and CEO of Johnson and Johnson. So it was actually a large business guy that they put in charge of this effort to encourage federal agencies to work with small businesses. And now his one of his relatives, I think maybe his grandson, runs the New York Jets, Woody Johnson.
Oh,
It's a big company in New Jersey, so it's got these New Jersey roots too. And Robert Wood Johnson was basically like SBA. He would go around to Army, Navy, and introduce them to small businesses. He was fairly successful. He did it for about a year, and a few $100 million to small businesses at the time. But the reason for that at the time in World War II was really about trying to take advantage of the small businesses factory capacity. So, they're trying to build, they're trying to make munitions, and they're trying to make military transport devices, and there are just not enough large business factories or traditional government contractors to make all of that. So small businesses at the time, this is during industrial era in the United States, had a lot of factory capacity that they were using probably for consumer products or something other than military products. And so getting small businesses in was a way to take advantage of America's full manufacturing capacity and production capacity, and giving them preferences, and going out to do that. So when World War II ended, they kept that program going, mostly because of the fear that there might be a further need for mobilization. Small businesses aren't as much important for their factory capacity anymore. So the reason for small business contracting has changed over time. Harry Truman was a big small business advocate. His reason, and actually the he gave a speech that eventually ended up him getting notoriety and becoming vice president and then ascending to the presidency. His speech was about how all these contracts, all these military contracts, were going to companies in New York City or the big manufacturing areas at that time, New York, Philadelphia, and they weren't going to the Midwest or to Missouri. And so his reason for small business, and I think a reason that still exists today is if the government works with small businesses, those contracts are more evenly distributed across the country, kind of geographic distribution rather than looking mostly at size. You're saying, okay, well, there are more small businesses in, say, Iowa than there are large businesses. So if we try to emphasize small business, then we'll get more money out to places that usually don't get this type of government spending. And then there's other explanations. In the 70s and 80s, as the 8A program was coming up, it was really a way for economic opportunity for people that had been excluded from the economy. So that's why the 8A program focuses on disadvantaged individuals, socially and economically disadvantaged individuals. And then you see the women-owned program, the service-able vet program. It has similar purposes. Service-able vet came out shortly after the Iraq War, and so you have a lot of veterans coming back stateside, and there's maybe not enough private jobs to absorb the population of veterans. So there's another opportunity for a veteran to find a good living and ascend to the middle class, and it's through the service-able vet program. So the VA spends over 25% of its contracting funding with veteran-owned companies. When I was at the SBA and I was in the policy role from about 2020 to 2025, a lot of the emphasis there was that the notion that small businesses are more innovative. They're more nimble. And there's research showing that small businesses spend more per capita, I think, on R&D because I think the explanation is actually because large businesses don't need to do that because they can just buy the small businesses after the R&D has been created. So small businesses create more stuff, maybe more patents per person, and they can come up with better ideas. And you kind of see some of that in the FAR overhaul too, with some of the strategies in Part 15 that we might be able to talk about. But one really interesting motivation for encouraging small business is one that I saw on Substack today. Noah Smith put out an article on small businesses. It's the idea that small business in the United States, other countries, he uses Japan as an example, is a gateway to the middle class. That there are people that maybe can't find jobs with like the big companies, Amazon or whatnot. He uses Walmart as an example, but you can start a small business fairly easily, and that's part of the things that we need to talk about in this FAR overhaul. Is it easy to start a small business and get into government contracting? And that can be a way to economic prosperity that's not available to everybody if they're just looking at trying to get an account executive job at a large company. And I think that's really the motivation that you hear out from people on the small business committees in Congress when you hear people at SBA talking about the virtues of small business. It's that small business supports the American middle class. It's a way to participate in the economy that isn't available if you're just looking at large businesses. And it's also a way to keep the government from going back to the same companies over and over. So in that way, it's like a anti-consolidation and antitrust measure to make sure that, and kind of like the Eisenhower speech about the military-industrial complex, that you don't have only large contractors that are in charge of all the buying decisions in the federal government.
So it promotes competition, which we love in the federal space and actually most procurement systems, for that matter.
And I mean, to that point, there's been research showing that when the government uses small business set-asides, and that's one of the main mechanisms for getting after small business, that's the main preference is the government can issue solicitations as set-asides, and there's only small businesses that can compete on those. There's more competition on those than there are on similar full and open contracts.
Oh,
You have more bids just because the small businesses, when they look at a full and open contract, they might not think they really have a realistic chance of competing against the large businesses. So they're more likely to bid when they know that they're only competing against companies that are like them.
wow, that's an interesting stat. Somebody should write more about that. I know someone.
You should
Um,
know.
yeah. So competition. One question I've always had with the small business program, and you know I've talked about this for many years because I've been obsessed with this idea of like small business compliance and the much higher rates of exclusion through our suspension and debarment program if you're a small company, and what role government should play in helping the contractors that they do or the companies they do attract to the federal space to understand their compliance obligations. And maybe we'll have time to get to that today, maybe not. Maybe that's its own podcast. But the one question I always have is a fundamental one, which is like, how do we define success in our program? How do we know if our policies are working? How do we know if the goals are really helping small businesses? And I say that because, as my colleague Schooner says religiously, what gets measured gets managed. You know, we track how many contract dollars are spent, or, you know, we want to make sure we hit our 23% goal, but does that really measure success in the program? So I pose that question to you.
I don't have an answer to what success means, but you're absolutely right that what what you measure drives policy. So here
Yes.
in the United States, we measure the number of dollars, just dollars that go to small businesses, not the number of contracts, not the number of small businesses that participate. It's just dollars. So the number of dollars has been going up. This year it might level off for 2025, but 2024 was a record. It's 28.7, way above the 23%, $180 billion, which was a record as well. But along with that, we've seen the number of small businesses that get contracts going lower and lower. It's gone down about 50% in the last 15 years. It may go below 60,000 in the next few years, and it used to be at 120,000. And then the number of contracts is going down, especially in some of the socioeconomic programs like the 8A program. And part of that is just consolidation with just a few businesses. You mentioned the emphasis on 8A, service-able vet, small disadvantaged business, women-owned, hub zone. There are other types of small businesses as well, businesses that are owned by Alaska Native corporations, Indian tribes, Native Hawaiian organizations. Those are a very big part of the small business and industrial base. And they get a lot of those small business dollars. That's been responsible for a lot of the increase in the dollars to small businesses. So as we measure the dollars, that's really what people have been focusing on. When I was at SBA and I was trying to push that goal, that's you mentioned, I would mention number of vendors is going down. We really need to try to reach out to more small businesses, do more outreach, do more market research. But at the end of the day, people are accountable for increasing the dollars, not increasing the number of participants.
Yeah, and I think that's a helpful way to look at it. You know, I one of the things that struck me is when I was, you know, talking to different agencies. This is a few years back because one of my articles deals with how to enhance compliance programs within small business contractors. Because again, if they have a compliance failure, that can lead to their elimination from the federal industrial base, and that's not something we necessarily want anyway. And so, you know, if you're spending all this time getting them to come, you don't want them all to be kicked out. And so the the challenge I had going office to office is that there just didn't seem to be an office even remotely interested in the idea of the government playing any role in it. And the one group I think, and this isn't a criticism of them, they have a very important role, but the OSDBUs, did some presentations to the OSDBUs about it, and it was like crickets because their whole goal is they're looking at the stats. I mean, their job performance, their expectations are based on like how many more companies do we reach our goals, that kind of stuff. How do we make it easier for them to come? But my favorite anecdote during this time period was that I was had a research assistant and I had him literally scour. I don't know if I shared this with you. I had him literally scour the entire like federal government website, all the websites, every single website that dealt with small businesses from each agency. And I said, I want you to find me an agency that gives small businesses compliance guidance so that they understand that they have all these compliance obligations. And SBA is the closest in terms of like small business compliance, but it had a lot of like resources on just like setting up a business generally. My favorite, first of all, none of them had it. None of them had any of it. But my favorite was one of the offices, and I think this was like Justice Department, and I'm not like calling out the Justice Department, but the website literally said, small businesses have compliance obligations. For more information on your expectations, here's a link. And it was a link to the Federal Acquisition Regulation. I kid you not.
Okay.
And as if that is somehow some practical guidance to help someone. If it was, I'd be out of a job. But nevertheless, I think there's always been this interesting aspect to it where we spend so much time bringing them. And by the way, this is your podcast, and I'm just taking it over. But you've always disagreed that maybe you disagreed or you just didn't think the government should play a role in helping with compliance. I can't remember where you stood on it.
I mean, now I'm on the outside. Pretty much all I do is small business compliance. So that's what I'm really helping my clients with. And the problem, as you mentioned, is you spend a lot of time bringing these companies in. That's the main role of the OSDBU. But the compliance burden on small businesses is much greater than large businesses because you have additional small business concerns about limitations on subcontracting, non-manufacturing, all these things that sound like legal gobbledygook, and they are because Congress named them. They give them terrible names. Like non-manufacture rule is not really about manufacturing anything. It's about just like giving products to the federal government, but that's what it's called. That's what Congress called it. And so, I mean, that's part of the reason why I have a Substack, GovCon Intelligence, is give people this compliance advice. I thought you were going to say that they directed people to the GW Law website, because I know you have a lot of good stuff on there about compliance. The real problem for small businesses is, first of all, trying to get started in the first place. So it's hard to, get your SAM registration, all these complaints about it's hard for me to get my cage code, and then figuring out certifications. Do I need to get a certification or not from SBA? And there's lots of people online that are trying to sell you stuff that you need to get. But then everything is actually in the contract. So it's not, even if you were to go and read the FAR, that wouldn't give you all the compliance requirements, because the compliance requirements are actually in the contract, and that changes over time. So we have changes in the limitation on subcontracting. How is that determined? Well, it depends on which clause is in your contract. Is it 2016 clause? Is it 2023 clause? Is it the new FAR overhaul clause? And then on the small business side, you try to keep below the small business standard, but then you have to worry about, are you affiliated with another company? And those standards change too, and they're mostly in case law. So there should be a one-stop shop for this sort of compliance advice. Maybe my website can aspire to be that someday. But it's certainly, you're right, it's certainly not something that the OSDBUs are as focused on.
Yeah, I will say I actually am setting up over the break of setting up my own website finally to have like a place where I can put over the semester and over the years I've developed so many resources that I want to just give away for free to people because I just use them as teaching tools and collections from like past presentations. So I'll have some for you and you can share with people, especially with the overhaul. I had to create so many different charts and guides and things to help people understand the distinction between the new rules and the old rules. So that's so hard, but that's a great. To me, it's like the unending challenge. I have one person once told me that small businesses should be exempt from every single compliance rule, and I did not like that answer as an anti-corruption and compliance person. But I'm not like naive to the fact that it's how hard it is. So I want to shift a little bit because we keep talking about the overhaul, but we haven't really talked about it. So it is, the elephant in the room. We are undergoing, and for those of you that are outside the United States that are listening or at the state level and not really paying attention, if you're in the federal space and you don't know about the overhaul, then I don't know what you must have a social media ban and all things on communication because it's all everyone's been talking about since the spring. But we now have all of the draft FAR parts where potentially or we're supposed to be going and heading into notice and comment for what these new rules are going to look like. But before we get to what you view as some of the impacts on small business, because that's what I want to spend the most time on, I want to talk to you about like your initial reaction because you just had a piece that came out. Was it the last 24 hours, 48 hours?
Just yesterday.
Just yesterday on the process. Now, when I've been talking about it with people, I often have to tell them we've got to separate out process from substance because so many people dislike the process and but like some of what they've seen in the substance. So talk to me about your piece from yesterday and kind of what your thoughts are on the overhaul process.
The process is unprecedented. No one's ever tried to do this before. The FAR Council issued this FAR overhaul as model deviations, which is a completely new term. I don't know that it's legal. The deviations were supposed to be that they're something that's FAR specific. They're in FAR 1.4, and it says if an agency has a special idea about how they want to run the procurement system just for their agency, maybe they're buying special stuff and they want a special rule, they can petition the FAR Council to get a deviation for their agency. The FAR Council completely turned that around. They said, we're going to tell you what your special agency rule is, and we're going to say it's pre-approved, and then some agencies pick it up. It was supposed to be that all the agencies would pick it up, but defense has not deviated. They have not adopted any of these model deviations. So that gives me some solace that really the biggest buyer has not gone ahead with adopting the FAR overhaul. So in a way, because you don't have the biggest buyer, they end up just kind of being drafts, and you can test to see within GSA or Department of Transportation has adopted a lot of them to see how these are actually going to turn out, and if there are mistakes in them that the FAR Council can go back and fix that using notice and comment. So it is interesting as a legal matter, based on some Supreme Court jurisprudence, to see how the FAR Council has tried to get around notice and comment for this first stage. They can make up for that during notice and comment. They probably have to go through different White House offices, OMB and OIRA. They have to go through SB Office of Advocacy. So they may be able to make up for all of these um, oversights in the end. But while we're waiting for it, it seems unnerving and a bit confusing.
You're so polite. I've been much harsher about it. Look, I think, and for anyone that's not familiar with it, that basically all of this yuckiness, the stuff that you and I are unhappy with, and that many of us in this entire field are unhappy with, is that the executive order basically gives them 6 months to overhaul our entire rule book. And so it's because of that time constraint that you see this process. How are you going to get it done in 6 months if you go through traditional notice and comment? And so, very smart people at JCA. And one of the things I've said repeatedly is that one of the biggest reliefs to me was that there were adults in the room working on this. Like, these are people that are knowledgeable, experienced, career professionals in our field, and you can just tell because many of us are familiar with them and know them well. Like, I personally love a lot of the substance, but I hate and consider, the process antithetical to like democracy, administrative law, whatever bucket you want to put it into. That's not how we do business. And frankly, it's a good reason for it. And so I agree about how it was done. And no one screamed louder than me or more publicly than me, who had to teach it within hours after these FAR parts are being released. The worst day was when my amazing, let me just say, amazing teaching assistant who has kept me sane, um, changed my slides within my commute from Virginia to DC. And I opened up my slides to teach, and I had brand new law sitting in front of me. And I said, okay, we've got to take a pause because I haven't even read this, and reading it to my students in real time is not a good use of anyone's time. But it shouldn't work that way. And that was the one day I think I had a bit of a rage moment, not at my students, but I was like, this is why we have notice and comment. And so, so I think there's the process, and I really appreciate it. And for anyone that hasn't, please go visit the link and go read Sam's piece on this, because you very thoughtfully walk through why you think it's not legal. And my colleague Chris Eukins has been complaining about it for months, that violates the OFPP Act. So I do think they're viewing the notice and comment that they may do now as their form of like ratifying
Right.
an
Yeah.
illegal process.
My
Um,
favorite part of it was when they changed FAR Part 8.
okay.
FAR Part 8, when it
Oh,
first came
yes.
out, and they had this mandate to use best in class contracts. And like within an hour, I was online saying, this is terrible for small business. 95% of small businesses do not hold best in class contracts. It's really going to decimate the industrial base. And people picked up on that, and there were other people that had the same point of view. And within 3 weeks, I think they changed. They sent an email to everybody saying, "Oh, there's not going to be a best in class mandate. We're going to call it required use. We're not going to tell you what required use means, but we're going to change it to required use." And if you go back to the website, you cannot find the best in class mandate anymore. They just completely erased it. So within 3 weeks, you can't do this with rulemaking. With rulemaking, you have to issue an amendment in the Federal Register. You got to get the administrator to sign it. This, they just go. It's just a website. You just go and you change the website, and it's like it never happened. I just when I was preparing that piece, I went back and I found the press release that the White House put out when they issued FAR Part 8. I don't remember why they thought a press release would be significant for Part 8, but they put in the press release that, oh, and now we're mandating best in class contracts. I thought, wow, this is the one place where you can see this mandate still existed. It's frozen in time. This is a historical document. Now it's as if it never happened.
Yeah, I mean, that gets back to an inherent problem that my colleagues in GW and I have had forever with like PGI, which is that this stuff can change at any time with no notice. And when you're consistently changing things that you say that, I mean, a lot of it's supposed to be implemented by now. That's difficult. And I think even I had it. I think in my original notes, I think I had best in class, and I think I've toggled in the way I talk about it. And I don't think I paid as much since I had to learn every single FAR part to teach it. I don't think I was as focused. I was more focused on like we're channeling people towards these specific vehicles when it to me didn't necessarily jive correctly with like this big preference for commercial first, which it might not always be. Maybe they're in alignment, maybe they're not. And I was also really focused on these kind of on ramps and off ramps and the amount of protesting that happens with these massive vehicles, which is just to me an issue with how these kind of it's like you have one shot at getting on this massive vehicle, and that's what leads to like our CIOS before
Uh,
debacles.
I mean, speaking of protests, when I looked at the best in class mandate, I thought, well, you can protest the mandate. If somebody doesn't, if an agency doesn't use the best in class contract, then couldn't somebody protest that because the rule says you must use the best in class contract? And then if the agency were to go forward with that and say, oh well, we followed the rule or we didn't follow the rule, then the whole overhaul could be at stake. You could have a judge or GAO looking at, can the overhaul actually do this, or is it following the right process under the OFP Act? So then maybe the protest portion of it, the fact that a mandate can lead to a protest, could have been the reason why they reversed the mandate and went over to required use instead of best in class.
What other impacts? And I think if most people look at it, they think about Part 6 and competition, they think about Part 19, obviously. What other impacts do you see on small businesses from the revolutionary FAR overhaul?
Uh, Most of it was not revolutionary. I'd say, the shalls and musts, like that's good, but I don't know that's revolutionary. Part 19 really does have a lot of policy changes. The biggest part of it, the most confusing part of it is that the policy changes are different from what SBA puts in its policies. So now you have two competing sets of policies governing the same contract action. How is this going to get settled? It's probably going to go to court. There's probably going to be lawyers involved. But things like, do agencies have to prioritize the socioeconomic programs, that's Service Stable Vet, Hub Zone, Women Owned, 8A, above just normal small business set asides? The FAR says no. SBA's regulations still say yes. I mean, the FAR is probably okay about that because there's been some GAO cases on that say that if agencies just have to give a look to the socioeconomic programs rather than doing serious market research on that. There's changes in the 8A program. There's a rule in the SBA regulations called the once 8A, always 8A rule,
Oh, right.
and the FAR changes that once it's 8A, it's not always 8A if you can find a service able vet, women owned, or hub zone set aside opportunity, then you get exempt from that rule essentially. So the 8A program gets less of a preference because of the change to the once 8A, always 8A rule. There's another change in 8A as well about trying to look at competitive multi award contracts before you use a sole source 8A contract. So that makes it a bit less attractive to be an 8A contractor because you're marginally less likely to get a sole source contract. The biggest change, and this may be more of a legal minutia thing, is the FAR overhaul changed all the rules on re-representation back from what they changed in January. So similar to what you were talking about with OCIs and FAR Part 9, there were all these changes in January on when you have to be a small business,
Right.
especially on an IDIQ contract. Do you have to be a small business at the contract level, or do you have to be a small business at the order level? And FAR just changed that in January, and then the FAR overhaul went and changed that all back to the way that it was before. SBA's rules are completely different, and that's going to be very confusing because if it gets up to a dispute, it really depends on whether that dispute goes to SBA, which makes size decisions, or say it goes to GAO or court, which may be more likely to look at the FAR.
Fascinating. I mean, two things I'm thinking of. I want to get to orders and the rule of two, and that the far overhaul impact on that. But my students are, they've asked like, what does this mean? What does this mean for us learning this stuff? And what does this mean for the field right now? Because we're obviously in this period of flux in terms of like hiring and working for the federal government or for contractors. And I said, I just keep reminding them we are about to enter a golden age of litigation because I mean, when I look at FAR Part 15's change, where we're basically decimating, the GAO asset, all this just years of what we, kind of government procurement common law with this massive, massive change, all of this is going to have to get hammered out in the courts. And so if you're interested in litigation, there's never been a more interesting time than now or like in within the next year. So I always keep reminding, hang in there, students, it's coming.
All the
Uh,
interpretation of these rules is up for grabs.
Yeah,
And
it
then,
really
SBA will
is.
probably come out with rule changes too. And so, the history that people have, like I came out into private practice and I felt like, oh, I have a lot of experience with SBA's rules. I have a lot of experience with the FAR. Well, now the FAR's completely changed,
Yeah.
and then SBA's rules might be changing. So I'm just as good as one of your students that's coming out of law school. They have the same amount of experience with these new regs as I would.
Yeah, somebody asked me a question the other day about Part 12 on my students during our exam review, and I was like, I have no idea. I have no idea how it's going to work. So your guess is as good as mine. Um, do you think that the new rule relating to maybe you want to tell everybody about the rule of two and the position that the overhaul takes on ordering under IDIQs, what that looks like, and what you think that impact will have on small businesses?
That was one of my biggest issues when I was at SBA. The Court of Federal Claims had issued a decision while I was in that position called Tolliver Group at late 2020 that said that the rule of two applies to orders.
Right.
That under the way that Judge Solemson, who's now the chief judge at the Court of Federal Claims, the way that he read the FAR, the agency was required when it issued an order to first look at whether there are two or more small businesses that perform that requirement, and if there were, to set that aside. So I brought that up to the FAR Council, and the White House actually got involved. OMB issued a memo saying agencies should follow the rule of two based on this case and based on policy reasons, and apply the rule of two at the order level. The FAR Council issued a proposed rule, SBA issued a proposed rule. Now, the FAR overhaul undoes all of that and essentially says the rule of two still applies for contracts, but for orders, agencies have the discretion on whether to use set asides. They can set it aside if they want to, but they're not required by some sort of rule under the rule of two to do that. The weird part about what the FAR overhaul says is that they say you can't protest that if it's not that you can't protest the rule of two, but you can't protest an order level set aside. And that seems wrong to me because it seems like you can just protest anything. Like, everything's subject to some sort of arbitrary and capricious standard rather than, even if it's within the agency's discretion, it still should be protested. Now, is that going to make a difference to small businesses receiving orders? Yeah, probably. At some point, it's really easy for an agency to get around the rule of two now because they can say the rule of two applies to contracts, but I don't need to use a contract for this requirement. I can just go to this multiple award contract and issue an order, and then I get exempt from the rule of two. So, as a strategy and maneuvering, it makes it easier for agencies just to avoid their small business responsibilities. Is that really going to make a big difference in whether agencies reach the 28% or 23% or 25%? That really depends on whether they're still motivated to use small businesses. There's been a reduction in the OSDBUs, and the OSDBUs are the small business specialists are cut out of a lot of the new FAR Part 19. Those are really the people that push agencies to use small business and to apply preferences and use these programs, that may have a bigger effect on the decline in the OSDBUs may have a bigger effect on agencies reaching their small business goals than this change in the rule of two.
Interesting. Well, obviously one to watch, and we'll see what happens and notice and comment on that one. Whenever that starts.
Yeah, that's a great point. That's certainly something for businesses to bring up. And uh, I made the point in my article yesterday that the FAR Council is required by Supreme Court case law, fairly recent Supreme Court case law, to consider and respond to all significant comments. So it's worth it for businesses that have a vested interest in these FAR overall changes. Rule of two is probably one of the biggest issues to file comments because it forces a response on the part of the agency.
Yeah, absolutely. So participate. Uh,
Yes, yes, this is your
um,
chance.
there you go. All right. Our last topic for today, I want to turn from the overhaul to consolidation. So a lot of times people have been focused so heavily on the new rules, which understandably they should, but have been somewhat less focused on the overarching consolidation that's happening under GSA, whether that is, again, consolidating much under GSA or even things to me like the use of like single award, really high dollar value single award BPAs with IDIQs, which understandably, again, we're dealing with like efficiency versus and potential cost savings versus small business, but all those changes are going to have a dramatic impact on small companies. And I think I said this at the ABA forum. It's not just a US thing. I mean, there have been countless examples and studies over the years, even outside the United States, that when you consolidate procurement, it will impact small companies. So I was just curious of your take on this.
That's going to reduce the number of small businesses that participate. Some of those businesses, some of the small businesses will be on those consolidated vehicles. Maybe they'll have good success at GSA, but it's not going to be the number of businesses that we have now that are participating. There's just not enough slots on all of those contracts to keep the industrial base at the size that it is now. My concern about consolidation is not so much that these vehicles exist or that GSA runs contracting. That's fine. At SBA, when I was there, they use other agencies for their contracting. I know GSA has had that service for quite some time. The vehicles have existed for a long time, Oasis. My concern is about the mandate to use them. These vehicles are so great. If they're so efficient, you get value for them and they're cheap. Shouldn't agencies just want to use them because they're better than the agency going out and having a contract on their own? Why is it that when the FAR is trying to streamline and get rid of the shalls and the musts and eliminate 35% of the must, the one area where they put in musts was to tell agencies that they must use these consolidated contracts. What why does that make any sense? Why do you need to put a thumb on the scales of these consolidated contracts when they're already supposed to be so good? I think that could lead to protests, but more so, it drives the agency away from being able to take advantage of innovation if it wants. If it wants to go and use a consolidated contract and just get whatever standard off the rack stuff is at what has already been discovered to be determined to be the best value, that's great. But if it wants to go in a different direction and do something that's more innovative, now the FAR is telling them, no, don't do that. Go and
Yeah.
use this contract that's already been set up by GSA. And I think that's a problem.
Yeah, I think out of anything that I've seen out of the overhaul that has gotten more people fired up, it's that piece. And I think you're absolutely right about the litigation. I mean, multiple cases my students read over the semester all deal with the same theme, which is like shall means shall, must means must, right? And whether it's, commercial preference or, a Unicore contractor or Ability One or anything that's required in FAR Part 8, shall means shall and must means must. So you're really giving no wiggle room for that. And it's tough to reconcile those two. And I do wonder if that is something that might change in notice and comment because there has been so much pushback that I've seen from so many people at different aspects, people coming from different parts of the procurement system about that one piece. So I think it's good that you've raised that. And overall, I think the other part of the consolidation is that once you kind of streamline everything into these kind of buckets, right, you leave a less opportunity for small companies. And it'll be interesting to see how this actually operationalizes. I mean, we talk about a lot of this. It's right now feels very kind of abstract. We're envisioning the worst case scenario. But who knows? The one thing I was curious though, putting small business aside, what's your overall impression? So I got asked by Roger Waldron on his podcast, what grade would you give the rest of the changes, which is so hard, right? And I actually said like an A minus because, as much as those are some big problems and I've highlighted them, what I love about it, and I think so many people have said it's not so much revolutionary as it is, it's like cutting a lot of the trimming away the fat. But I love the reorg. And so much of it is done in the procurement life cycle. So much of it is like what I love what they did with like 12 and 13. And then, some people are like, oh, 13's gone. I'm like, no, it's not. It's the commercial parts moved to
Right.
12. Makes so much sense to me. So I'm curious what your take. Maybe I grade inflated. So I'm curious.
Isn't that common in law schools now?
Not GW.
I'd have to think about a grade. I guess my job was actually giving grades out. When I did the
You
SBA
should.
scorecard, I give a grade to every agency, and there were a lot of complaints that most of the agencies got A's. I think we gave out 22 out of 24 A's
Oh, so
the
you grade
last year that I
inflated
was
at the
there. So I
SBA.
had grade inflation as well. Uh, you know, it. I'm so used to the normal FAR. I mean, I've been working under it for 20 years.
Right.
Most of it at the SBA. I've worked on a lot of Part 19. I don't I don't understand the rationale to moving a lot of this stuff to the bind guides and the companion
Oh,
guide because
yes,
I think there's
yes.
going to be a market for someone just to print all of that stuff out, put it in a PDF that's probably going to be the same size as the FAR. It's probably going to end up being about 2,000 pages when it's all said and done. I do like the companion guide though. There's a lot of interesting material in that, the stuff on architecture engineering. There's that best value continuum. I like the infographics they put together. So they've done a great job on the companion guide. I hope that will be a living document that they can put more things in as they develop.
Yeah, I think I remember with this outset where I was literally thinking about every single thing that these poor contracting officers now have to read as you like move things to different locations. That really worried me because you're just putting more on the plates of people where half their offices have been gutted,
Yeah.
and it goes to like the bigger theme of like the piece I did with Steve on institutional amnesia and our recent podcast on kind of workforce issues. But I do think that's good. I actually like that they moved the ordering procedures for GSA into um, the GSAM. And to me, that makes sense because of how hard it was for them to make changes going through the FAR Council. So some of these things I think were good, but I think this kind of sub-regulatory aspect to so much of it is going to be. I get it. You're supposed to give more discretion, avoid tripwires. I understand the rationale behind it, but we know our field, and it's gonna just be a field day for litigation. That's my impression.
Get ready for that $1 billion single award BPA.
Oh my God. Oh, I didn't even think that just sounds horrifying. And here's one question actually I have for you, is maybe we'll end on it. So, and it's unfair because I didn't tell you this in advance. But one of the things that consistently amuses me is the difference between bundling and consolidation. And tell my students all the time that they say, well, what's the difference? I said, it's eye of the beholder. If you're a small business, it's bundling. If you're a big business, it's consolidation. So is there a difference?
There is a legal difference. You're mostly right. Bundling is where the agency uses, it ends up with a contract that small businesses would be unlikely to receive. Consolidation is any type of combining contracts. They're both bad, but
Yeah.
consolidation is less bad because could result in a small business contract. There are plenty of small businesses that win consolidated contracts. They really shouldn't be winning bundling contracts as part of the definition. Bundling
Interesting.
is growing, even under across administrations, bundling is at an all-time high.
Oh, wow.
Congress keeps passing things to say you need to report more on bundling, you need more transparency, but they haven't really closed it down, and that's created an opening for agencies to continue to bundle and take opportunities away from small business.
Fascinating. I actually had this was like a year and a half ago. I mean, this is a year ago. I made ChatGPT do a side by side chart comparing bundling and it literally looked like just the same thing on both sides with different words. But it was like a year ago ChatGPT, so who knows what it would say now.
Probably worse
So
now.
with all the garbage we're feeding into everything. Well, I have to say, I could probably spend the rest of the day talking about this with you, but we are mindful that people probably don't want to spend 12 hours thinking about small business issues. So if you love this and you're interested in the topic, I'm going to direct you back again to Sam's newsletter because honestly, I get a lot of different newsletters and I read them with varying degrees of interest. It's awesome. And every single one you come up with, it's thoughtful, it's well researched, and it's super timely. So anybody who hasn't, read your newsletter. And thank you for taking time today to talk about these really important issues. And I think we'll probably get back together again, have you come back on once we hit notice and comment or after notice and comment to talk about, your thoughts once we have some changes.
Let's do it. It's been a lot of fun. Thanks for having me on.
All right. Thank you.
Thank you for listening to Beyond the FAR. Be sure to subscribe so you don't miss future conversations at the intersection of law, policy, and practice.